Good afternoon, and welcome to our annual Scribes webinar, Pop Culture References and Humor in Judicial Opinions. No laughing matter. I'm Justice John Browning. I am the president-elect of Scribes and a former justice on Texas's Fifth Court of Appeals and a partner at Spencer Fane. I also serve as distinguished jurist in residence at Faulkner University School of Law. We have a stellar panel joining us today. I'll introduce our judicial panelists first. The Honorable James Ho is with us. He is a circuit judge on the U.S. Court of Appeals for the Fifth Circuit. Prior to joining the bench in January 2018, he was a partner and co-chair of the National Appellate and Constitutional Law Practice Group of Gibson, Dunn and Crutcher. Judge Ho graduated from Stanford University with honors and also received his law degree with high honors from the University of Chicago Law School. He's authored numerous articles in respected law reviews nationwide, including an annual feature on exemplary judicial writing for the Greenbag. He clerked for Judge Jerry Smith on the U.S. Court of Appeals for the Fifth Circuit and for Justice Clarence Thomas of the U.S. Supreme Court. With us also is his colleague from the Ninth Circuit, the Honorable John B. Owens. Judge Owens, as I mentioned, is a U.S. Circuit Judge for the U.S. Court of Appeals for the Ninth Circuit. He received his bachelor's degree from the University of California, Berkeley. He received his law degree from Stanford Law School, graduating first in his class and earning the Stanford Law Review Board of Editors Award. After law school, he clerked for Judge J. Clifford Wallace on the U.S. Court of Appeals for the Ninth Circuit, and afterwards for Justice Ruth Bader Ginsburg on the U.S. Supreme Court. His practice career included stops in the Department of Justice, as a litigation attorney at O'Melveny and Myers, and as an assistant United States attorney with the Central District of California before joining the firm of Munger Tullis as a partner. We are also pleased to welcome Professor Tessa Dysart she is Assistant Director of Legal Writing and Clinical Professor of Law at the University of Arizona James Rogers College of Law. She serves as Editor-in-Chief of the Journal of Appellate Practice and Process, published by the University of Arizona Law School. Professor Dysart writes and speaks nationally on appellate advocacy issues. She is the co-author of the third edition of Winning on Appeal, Better Briefs and Oral Arguments. She is a graduate of Willamette University and Harvard Law School. She clerked for the Honorable Dennis Shedd on the U.S. Court of Appeals for the Fourth Circuit. She practiced with the U.S. Department of Justice, Office of Legal Policy, and the Senate Judiciary Committee, and has taught appellate advocacy and constitutional law courses at a number of other law schools. We're also pleased to welcome from the world of practice, Jason Steed. Jason is an appellate attorney with Kilpatrick Townsend with extensive experience in state and federal appellate courts across the country, including argument before the Supreme Court of the United States, the Supreme Court of Texas, Supreme Court of California, and the Supreme Court of Alaska. He's been listed in Best Lawyers in America for Appellate Lawyer, Best Lawyers in Dallas, Texas Super Lawyer, and other accolades. He received his bachelor's from Brigham Young University, his master's in fine arts from the University of Idaho. He holds a PhD in English literature from the University of Nevada, Las Vegas, and in a prior life was an English professor. Before going to what I can objectively state is the greatest law school in the country, the University of Texas School of Law. We also have with us my good friend and colleague, Chad Baruch. Chad is a board-certified appellate attorney in Texas with Johnston, Tobey, and Baruch in Dallas. He is a veteran appellate attorney, having presented oral argument in state and federal courts on more than 60 occasions, being a member of virtually every super lawyer accolade for appellate practice that one can imagine. He received his bachelor's from the University of Minnesota and his JD from the University of Minnesota School of Law, where he was a Royal Stone Scholar. And one of Chad's many claims to fame, besides his extensive career as a leader in our bar, is having written one of the most acclaimed legal briefs in history with the New York Times and Rolling Stone called the Hip Hop Brief. And I think that's certainly going to be something referenced given today's topic. To all our distinguished panelists, let me wish a warm welcome and my thanks and the thanks of Scribes and all our attendees for your participation today. Let me set the stage, if I may, for this topic, and just say that this is certainly an entertaining topic, but one that presents some divergence of opinions. Should judges employ a style that occasionally incorporates humor and pop culture references? Not long ago, in deciding the enforceability of a non-compete agreement, a judge referenced a Taylor Swift song, concluding that the losing party just couldn't shake off the restraints of the contract. Another judge, evidently also a Taylor Swift fan, Central District of California Magistrate Judge Gail Standish, channeled her inner T Swift, sprinkling her lyrics with references that the plaintiff was never, ever, ever going to get his case back in court. But for now, we've got problems, and the court is not sure he can solve them. His complaint, after all, had a blank space, and he was required to do more than write his name. And for the moment, defendants have shaken off this lawsuit. Another case involving administrative regulations for craft beer makers had a judge liberally sprinkle in to an otherwise dry subject alcohol-themed puns and beer references, describing how certain arguments fell flat, how the losing party's argument was all foam, and so forth. Judges, as we'll see, have channeled influences ranging from Star Wars to Star Trek, from Gilligan's Island to Seinfeld, not that there's anything wrong with that, from Shakespeare to Dr. Seuss, from Wayne's World to Game of Thrones. And if you don't believe me or think that this is just something that, a otherwise obscure judge might sprinkle in, no less a figure than Justice Elena Kagan on the US Supreme Court cited Dr. Seuss in Yates versus United States in 2015, in agreeing with a fisherman's argument about a law requiring fish not to be or to be tossed over, and whether or not they qualified as tangible things within the meaning of a particular federal statute. Justice Kagan, in dissenting, wrote, "A fish is, of course, a discrete thing that possesses physical form. See generally Dr. Seuss, one fish, two fish, red fish, blue fish." And she is certainly not the only judge who has channeled her inner Dr. Seuss. A federal judge in New Hampshire, in responding to a prison inmate's $10 million lawsuit complaining about the prison diet and attaching a hard-boiled egg to his complaint, responded as follows: "I do not like eggs in the file. I do not like them in any style. I will not take them fried or boiled. I will not take them poached or broiled. I will not like them soft or scrambled, despite an argument well rambled." And he ordered the egg destroyed and the complaint dismissed, stating, "No fan I am of the egg at hand. Destroy that egg today, without delay." It's provided fodder for lawyers like me to do articles devoted to pop culture references such as Star Wars, Star Trek, Game of Thrones, Seinfeld, and so forth in judicial opinions. But it can serve a legitimate purpose, and I think we'll hear more from our panelists about this. Very recently, in discussing the Stop Woke Act in Florida, the federal judge interpreting that act and hearing a challenge to it, U.S. District Judge Mark Walker, flexed his pop culture muscles, referencing the hit Netflix series Stranger Things, and while suggesting that the bill's restrictions on employer training could only be plausible in an alternate and deeply different parallel universe. And he referenced the upside down, describing a parallel dimension containing a distorted version of our world in the show Stranger Things, and said, recently, Florida has seemed like a First Amendment upside down. Normally, the First Amendment bars the state from burdening speech, while private actors may burden speech freely. But in Florida, the First Amendment apparently bars private actors from burdening speech, while the state may burden speech freely. And like the heroine in Stranger Things, this court is once again asked to pull Florida back from the upside down. So judges have considerable discretion in their opinion writing. Some adhere to a more rigid formal style that is solemn in tone. Others employ a more conversational tone or strive to create a more engaging narrative. Legal scholars and judges alike differ on the reasons why some judges employ humor or pop culture references, just as they may disagree on the larger question of what is the judge's role and what is the purpose of a judge's opinion. These same stakeholders may also disagree on whether such writing styles may interfere with a judge's ethical duty of impartiality or even threaten the integrity of the adjudicative process. Those who support judicial use of such lighthearted flair point to the admirable goal of making the mundane more accessible to the broader audience that judges serve. Critics of the practice, on the other hand, argue that such references and humor improperly detract from the serious nature of a court's work and can even veer into being unfair or disrespectful to the litigants themselves. At stake, these critics argue is nothing less than the integrity and impartiality of the judicial role and the legitimacy that we accord to judicial opinions. So the ongoing debate over judicial use of humor and pop culture references is the subject of this Scribes webinar, featuring our distinguished panelists from the world of the federal appellate bench, from the legal academy, and the world of appellate practice. So let me begin with our judges, since judicial opinions is the focus. First, Judge Jim Ho. In some ways, you're my hero when it comes to writing. I've long admired your writing, both prior to your taking the bench and since you've been on the Fifth Circuit. In one opinion, you managed to make references that range from Shakespeare's Macbeth to the Will Ferrell comedy Talladega Nights, The Ballad of Ricky Bobby. Truly quite the range. What are your personal guidelines when it comes to incorporating any pop culture references or humor into your opinions? And if you don't mind illustrating with some examples, that would be wonderful.
Sure. Well, first of all, thank you for the invitation to be with you all. I'm honored and delighted to be with this very accomplished panel. Thank you for the kind introduction, and it's a great and interesting topic. If the question that's essentially posed to the group, is the use of humor or cultural references and opinions, is that something that we should praise or condemn? I want to give a very hearty, robust, resounding maybe, or something in the middle. Let me start with sort of a statement of general principle, which is, as lawyers, as judges, we have tons and tons of things to read. We are basically every day buried in reading material. And so I think it goes without saying for all of us, and for hopefully, I presume, many of the audience, the experience of reading bad writing just makes the work that we have to do every day that much worse. So at an absolute minimum, and I know this is something that Scribes talks about a lot, and I love the organization, love the publication. At an absolute minimum, writing should be accessible. It should be easy to follow. It should be communicative. Short sentences, strong transitions, readable paragraphs, et cetera, all the things you guys talk about. Ideally, you go for more than that. Ideally, you go for more than accessible. You actually dare to go for enjoyable to read, or at least not a terrible experience to read. And in trying to get to that level of enjoyability, on rare occasions, the use of humor or the use of a cultural reference could be helpful in lightening the load for the reader. It can help alleviate the dreariness. It might even, as I say, make the experience enjoyable. I'll give you an example from one of my colleagues. It was an opinion written by James Graves, a member of the Fifth Circuit and a good friend. The case was about the parties trying to combine ketchup and other condiments into a product, mayonnaise and mustard, that sort of thing. Someone produced this product and they trademarked it as Metchup. And the opinion noted that this product didn't do very well in the marketplace. And I think the quote is, "For better or for worse, the market is not covered in Metchup." And I thought that was just a very kind of a nice, clever way of kind of capturing a part of the narrative that was important to the legal analysis. Cultural references, that's the use of humor. Cultural references can have the same kind of lightening of the mood effect. But like the use of humor, you want to be very, very careful and circumspect about using it. So to one, you don't want to be distracting or unprofessional, and you certainly emphatically do not ever want to be disrespectful. So if you're going to make a point, hopefully you make it quickly. It's an aside at worst, and it doesn't become dominant or show-offy. Second, and it's related to the point about disrespect, you do want to be very, very aware of what's at stake in the case. I would be especially wary. I don't want to say never. I certainly don't want to be critical of any colleagues, but I would be at least wary of using humor or a cultural reference in a criminal case, in a case where somebody's life or liberty is being threatened, and that's regardless of who wins that case. If the losing party in a case is more of an institutional party, the government, a company, an organization, I think that's probably a consideration as opposed to a human being, an individual person. And then third, and perhaps I'll spend the most time on this briefly, the cultural reference should, at an absolute minimum, should be directly relevant to the dispute at hand. I'm not sure all these examples you use, I'm not sure if they were all actually relevant to the legal dispute in the case. I would say that it really needs to be relevant, and not just because you wanted to make a fun point or want to be quoted. Ideally, you strive for even more than relevance. Ideally, you strive for a reference that reinforces the substantive legal point that you're trying to make, because that will help further make clear you're not trying to grab attention. You're really just trying to help illustrate a point in a hopefully enjoyable way. Quick examples, I once quoted the Dead Poets Society movie. It was to make the substantive point that when a student, the case happened to be a student case, when a student refuses to participate in an expressive activity, that refusal to participate can itself constitute a form of expression. And the Dead Poets Society has a perfect scene, perfect moment that captures that in a way that's literally the same as the case in front of us. A student not wanting to participate in a school function, a school expressive activity, and the teacher punishing the student for that. I quoted Die Hard 2 once in a qualified immunity case. Qualified immunity, as you know, can involve whether a violation of the Constitution is obvious enough to the officer to hold them liable. I quoted Die Hard 2 to make the point that it should be obvious to police officers that journalists have First Amendment rights. I quoted Goldfinger to make the point that if something happens not just once, not twice, but 3 times in a limited period of time, that might not be a coincidence. It might not be a fluke. It might actually be a real pattern. Again, directly relevant to the standing analysis presented in that case. I once quoted the Bible, Psalm 15:4, on the importance of keeping your oath, especially when keeping your oath hurts. And I use that to acknowledge our duty to follow precedent, whether you like that precedent or not, whether it leads to a result you cheer or are horrified by. Finally, and I'll admit this was an area where I absolutely went overboard in quoting and using Hamilton. The case was involving Hamilton. It was a case about the federal constitutional provision regarding export taxes, something that Hamilton was a key figure in the debate over whether we should have export taxes at the federal level. So I opened by using quite a bit of lines from the Hamilton musical. There's direct relevance. I don't claim that the entire thing was necessary to make the point. Hopefully the other examples were. I'm just a big fan of the show, to be honest, and I decided to at least exercise one moment of poetic license.
Thank you, Judge. And before we go to Judge Owens, I think Chad Baruch, you wanted to weigh in on I think a Judge Ho opinion that.
Yeah, he mentioned it in passing, but probably didn't do it justice. But it goes directly to the point he's making about really advancing the legal argument of the opinion in that qualified immunity case. His reference to Die Hard was like probably one of the best examples of that you could ever read, because the argument the police were making was that, where's your case, right, Eddie Izzard? Do you have a flag? Do you have a flag? Do you have a case? And that reference was to say this isn't just an ingrained part of our law; it's part of the cultural lexicon. Like the point we're telling the police is, yeah, you can't arrest a reporter for doing their job isn't just part of the American legal landscape; it's part of the American cultural lexicon, to the point that even Bruce Willis movies talk about it. So I just thought that was one of the very best examples I've ever seen of the point of it wasn't a look at me thing. It was this really does explain the legal principle I'm articulating in the opinion.
Well, and I think that's an excellent segue to Judge Owens, because you have used, I think, some pop culture references to make what otherwise might be viewed as fairly dry, sometimes even dense legal doctrine, far more understandable and accessible, I think, certainly to a broader audience, but I would dare say to judges themselves. In July 2019, Judge, you wrote an opinion in Lindy Banks versus Northern Trust, a case about the scintillating topic of breach of fiduciary duties, in which you made a point about how the court would not disregard legal precedent in the matter. In that matter, quote, the way that Game of Thrones rendered the entire Night King storyline meaningless in its final season, close quotes. First of all, as a fellow Game of Thrones fan, I almost wore my House Stark bow tie in your honor today. I applaud the reference, but second, tell us how pop culture references like that can communicate or make a complex legal subject more accessible.
Well, again, thank you for putting this together. Thank you for including me. And I echo much of what my colleague, Judge Ho, said, that it is a tricky dance, right? I have not always danced on the right side of the line. I will confess that, of writing something because it interests you versus writing something that actually helps the reader and compels them to a certain outcome. I will tell you that the first time I saw that used effectively that I can recall was an opinion in the 1990s by Justice Ginsburg. It was a dissent in a case called Muscarello versus United States. And it had to do with the definition of carrying a firearm. We all remember the Bailey case that was about using a firearm under 18 U.S.C. 924C. The next question was, what did carry mean? And Justice Ginsburg dissented in that case. She took a narrower view of the term carry than the majority did. And in so doing, she actually quoted from Sesame Street, saying one of these things is not like the other. And there was a line from Magnificent Seven, which talked about carrying responsibilities. There was a line from MASH where Hawkeye, the Alan Alda character, talks about, I carry this, I carry that. And that was really the first time I saw it. And I actually thought that was very effective because it was using popular culture, and it was her, in a way to show that the word carry can mean a lot of different things. And I think that's a good example of where I think it's the appropriate way to use it. to really show the reader how to do it. Now, with the stuff I've done, I will confess, many of them were not as enlightened as Justice Ginsburg was. The one that you referenced, that was actually the first time I had ever taken a recommendation from a law clerk. So how do these things come up in my head, right? That's just the way I talk. Like, I'll give you an example. We had a criminal case one time, and the defense attorney was in a really tough spot. And I said, well, that's a Kobayashi Maru. And I'm referring, of course, to the no-win scenario from the Star Trek movies and from 2 Star Trek movies, actually. Now, unfortunately, the law clerks had no idea what I was talking about. That's one of the things to be careful with these references, is that, does your audience know who they are? I mean, if my grandfather was putting Laurel and Hardy references in something, I probably wouldn't get them. My kids don't even know who Laurel and Hardy are. So you do have to be careful with these types of references, as I suggest. But sometimes I think they can be helpful to really explain something in a way that kind of brings the reader in. And that's what I try to do. But I will confess, sometimes I have crossed the line. But with me, they all are organic, except for the one you just mentioned. All the rest of them have been, because I'll read a case, I'll say, well, that's like this. And I'll write it down. But I also have to be respectful. Just like Judge Ho said, if it's a wrongful death case, I mean, that kind of stuff should not be in there at all. Whenever I do it, I'm trying to use it to characterize an argument that the parties are making rather than the parties, number one. And number two, if it's a wrongful death of that type of case, I don't go anywhere near that. So, it is something I do. I will notice this is interesting because I went back to look. When was the last time I did this? And it was before COVID. So you talk about COVID changing the world. Maybe it's changing me because I haven't done it since COVID. Maybe coming out of COVID, maybe you'll see a little bit more. But I do try to not always succeed, but I do try to make it so it does illustrate the point. But in going back in this exercise to prepare for today, I did look back and I thought to myself, would I still do that today? Yeah, judges learn on the job, and that might be one of the examples. So I might still do some more, but a couple of the references I had in there were a little like Joe's suggested, were maybe not as helpful as they should have been. But overall, I think it's a good thing. Like Justice Ginsburg and Muscarello, I thought her examples really helped. And I think the qualified immunity example that was brought up earlier is another really good example. Until the Supreme Court clarifies what qualified immunity really means, maybe we got to look to Die Hard 2, which is a very underrated movie, very, very forgotten movie. It's very good.
Thank you, Judge.
By the way, it's also a Christmas movie.
Yeah.
Yes.
I agree.
Yes. Two Christmas diehards in a row. Judge Owens, and just to give you fair credit in flying your geek flag proudly, you've channeled and referenced the Twilight Zone and made other references. But the one that I mentioned was not your only Game of Thrones reference. You also, in Flores versus City of San Gabriel, you were trying to analogize an interpretation of a point regarding citing rejected case law, resurrecting case law. And I believe you referred to it as coming close to a Hibernian resurrection, referencing the Maester on Game of Thrones who created the zombified version of the Mountain. So kudos to you on doing that. And I think you certainly got across your point about rejected case law standards being better off left dead.
And if I could jump in on that one, that was the first time I'd ever done it. And that's an example where that's just how I speak. Yeah. That's just like, well, that's like that guy in Game of Thrones. He keeps resurrecting dead things. Like, that's how it comes up. And that's why usually there's not some master plan. It just kind of pops in my head. The other thing I would say is that I'm much more comfortable doing it, writing separately, than asking my colleagues to sign on to it. Now, I have done some times where I have done it in majority opinions and they have signed on, but I'm kind of putting them on the spot when I do that, honestly. So it's much easier for me to do it in a dissent, a concurrence, something like that.
Now, Judge Owens and Judge Ho, you both mentioned this being something that occurs, I think, for both of you very organically. That's an extension of your personalities and how your writing communicates, as opposed to being something that seems more consciously crafted. And the different end of the spectrum, I think. I think of a judge back in the early 70s from the Fifth Circuit and early 80s, Judge John R. Brown, who got some small level of notoriety because he would work in references in different opinions. He wrote one about, I think it was City of Houston versus FAA, about the federal ban on nonstop flights between Washington National and other airports. And he found a way to work in all kinds of references to airlines and their slogans, like "Fly the Friendly Skies" and things like that. His opinion was very consciously full of that. He had another one involving the detergent industry and regulatory issues in it. And he worked in a whole bunch of references to different names of detergents and soaps. One line from that is, "It is plain as Mr. Clean, the proper action is that the Dade County ordinance must be superseded as all comes out in the wash." He did another one involving the soda industry and somehow wove in the names of a bunch of sodas. That was certainly a different approach than both of you have described, of this thing being kind of an organic extension. And if you don't mind, if we could just hear from each of you, is there a place in opinion writing for a judge to take that sort of approach? I also think of a Ninth Circuit predecessor of yours, Judge Owens, Judge Kaczynski, who achieved underground fame for working in a ridiculous number of movie title references in an opinion. What is there a place for this more consciously crafted aspect of opinion writing?
Well, I'll take a quick stab at it. I alluded to the time I used Hamilton, and it sounds like the examples that you're citing with Judge Brown sound sort of similar, and sort of like sprinkling lots of references. I noted that I only did it once because I do think that's something that you want to be very careful about. In my example, as I said, Hamilton was an important part of the history of the clause that we were looking at, and so I did an introduction that told the history of the clause, but through various quotations from the musical. That is personally speaking, purely personally, and not trying to be commenting on whether others should be doing or not. I don't think it's something that should be done very often. I seriously doubt I would ever do it again. I don't never say never, but Hamilton was so important to the export tax clause, and candidly, just a show that I think is so wonderful, as well as frankly important for various reasons, that I felt that I could sort of use one of my three lifelines, if you will, to make an exception. I don't know that I would do that as regularly as I trust Judge Brown decided. Now, I'm not saying he was wrong to do it. I'm not sure I would do it.
Judge Owens?
I feel the same way. I think the occasional reference is, and over the years, judges have quoted from Shakespeare, or quoted a character from Shakespeare, a Iago or a Hamlet or Claudius, whoever it might be. That's one thing, but then to turn an opinion into Hamlet or turn an opinion into Romeo and Juliet, that's different. So I agree with Judge Ho. If it's to be done, it should be done very sparingly, because if you want to be a screenwriter or a comedy writer, you can go do that. Right. I think as judges, that's not our primary purpose. And if it looks like it's our primary purpose, I don't think that's a good thing. So I think the one-off every once in a while is okay. But I agree with Judge Ho. That's a pretty hot oven. You probably don't want to keep your stove, I should say. You don't want to keep your hand on it very long.
Now, Judge Owens, one of your colleagues on the Ninth Circuit, Judge Kenneth Lee, drew some mixed reactions of his own for his pop culture reference in a case involving ConAgra Foods, Wesson Oil, and the subject of illusory promises. He analogized the situation in which a promise was illusory to the case to Star Wars, writing, "That is like George Lucas promising no more mediocre and schlocky Star Wars sequels shortly after selling the franchise to Disney. Such a promise would be illusory," followed by the footnote that he added, "as evident by Disney's production of The Last Jedi and The Rise of Skywalker." putting my own opinions as a Star Wars fan and not a fan of the sequel trilogy, I'm inclined to agree with Judge Lee. Please feel free to pass that on. But he got quite a reaction, including from some folks in the academy about whether this was appropriate or not. Professor Dysart, I know you weighed in on the wonderful blog, the Appellate Advocacy blog, which I'll put in a quick plug. I think the world of it. It's a regular bookmarked item for me. I've had the privilege of being a guest blogger for it, and I encourage everyone to read the Appellate Advocacy blog. But Professor Dysart, you've weighed in on that specific reference and on the larger subject at hand. Could you tell us some of your thoughts on judicial use of humor and pop culture references?
Sure, and thank you so much for inviting me. It's an honor to be on this panel, and I apologize that I both have cat fights and a Zoom bombing toddler today. This has sort of been my week. So I think as a general matter, the criticism of pop culture and humor, which I think are two very distinct categories. So the use of humor is distinct from pop culture, which is also then distinct from narrative and analogy and other stylistic devices. But often the criticism really boils down to, do you like the authoring judge or that authoring judge's appointing president, or do you like the outcome of the opinion? Not always, but often. And when I teach con law, I always tell my students their view of presidential power shouldn't depend on who the president is. And likewise, I think your view of humor and pop culture shouldn't depend on the authoring judge or that judge's appointing president. So I'm going to sort of set that as a ground rule. On the flip side, a lot of times, and this was certainly the case with Judge Lee's use of humor, when I read opinions from judges that I know personally from law school or from work, it's easier to, and I'll try to put the link to the Appellate Advocacy blog in the chat. I see a couple of people asking about it. So when I'm done, I'll pull it up and put it in there.
Thank you.
But multitasking, like the mom that I am here, got a lot of things going on. I'm friends with Judge Lee. Judge Van Dyke on the Ninth Circuit also uses humor and pop culture. He's a dear friend from law school. Judge Oldham, I know it's mentioned in one of the articles, is a friend from law school. So sometimes I view the references and I view it in a lens of knowing them as a person. So Judge Lee, huge Star Wars fan. I mean, Star Wars fanatic fan and baseball fan. And so when I see those references and his opinions, it doesn't surprise me because that's who he is. So in terms of the use of humor in pop culture, let me start with pop culture. One of the drawbacks of pop culture references is it a timeless reference, right? So if I was writing an opinion as a judge in 2020 and I referenced the Tiger King, that would have made a lot of sense to people in 2020, but in 2030, are people going to remember, Carol Baskin and the Tiger King and that whole drama? Probably not. And so enduring references, Star Wars, Star Trek, Harry Potter, one of my favorites, Dr. Seuss, I think those are really good pop culture analogies to use. And for me, bringing those in is making an opinion more accessible. Should we want the public to read and understand judicial opinions? And I think yes. I think making what happens in the courtroom more understandable and more accessible is an extremely important part of judging. Things to consider, and the judges have already mentioned this, and I wholeheartely agree, is to be respectful to the parties and to the gravity of the situation. So, thinking, is this going to, it'll probably offend someone because that's the world we live in. But generally, is this respectful to the parties and to the particular situation? Does it detract from the readability of the opinion? So some of the examples that we've talked about, writing things in verse, in the references, perhaps the soap or the airline references or the Taylor Swift references, could those be so distracting that they just seem forced and really take away from the gravity of the situation? But if you're using humor or pop culture to either draw your reader in, like the example, Judge Oldham in the Williams case, where's the beef, drawing your reader in, or using it to clarify a complex legal principle, I think that can be extremely valuable and helpful.
Professor, you mentioned sort of the shelf life, the limited shelf life, and that's something I've struggled with in certain references that, you know, I have to remember it's got to be someone everyone can relate to. It has to have a certain timelessness. And I was, when you mentioned Dr. Seuss being an example of that, I was remembering a fairly recent, you know, a few years ago, Fourth Circuit case in an environmental law case that involved a permit issue about whether or not a certain pipeline could cross national forests. And the court, in deciding that the Forestry Service had abdicated its responsibility to preserve natural forest resources, quoted Dr. Seuss's The Lorax, saying, "We trust the United States Forest Service to speak for the trees have no tongues." Just a reminder that you can be direct and meaningful in terms of getting the point across, communicating both the gist of the case and doing so with what is a timeless, I think, pop culture reference. So thank you.
Could I say a quick point to that? It's funny though, because as a professor, what I think is timeless isn't always true. So sometimes I hide a question in my syllabus to make sure my students read it, and they're supposed to email me the answer. And it's usually something mundane, like your favorite part of the Constitution or your favorite Harry Potter, you know, character. I'm a big Harry Potter fan. And one time I had a student respond back, "Well, I haven't seen the movies." And I was just appalled, and it makes me feel old. So I think evaluating what is an enduring reference is can be difficult sometimes.
Well, I tried the "Where's the Beef" reference that worked so well for Judge Oldham, and I thought it was wonderful in Judge Oldham's opinion. I tried it, and my law students couldn't remember the commercial. So again, references lost on younger audiences sometimes. Chad Baruch. Chad, as I mentioned in the introduction, you attracted national attention with an amicus brief on behalf of noted hip hop artists in which you incorporated hip hop and rap lyrics. Let's talk for a moment about how the role of an advocate using humor or pop culture references may differ from that of a jurist. What sort of considerations do you work through as an advocate?
Sure. I mean, I guess the first thing we should point out is that the hip hop brief was kind of different than what we're talking about in the sense that we weren't using hip hop lyrics to illustrate other points. The case actually was about hip hop lyrics. So it was a little bit different situation than the use of cultural references to advance some different point or argument. They were actually at issue, much the way I think the recent brief, you know, by The Onion, kind of the same thing. I mean, the case was about parody, so the brief using parody really was, that's what the case was about. It wasn't just in service of some different point. I mean, I think it's very different because we're expected to be advocates. We're not expected to be neutral or detached, or, you know, certainly we're expected to abide by the ethical rules, be respectful, and those sorts of things. But we are expected to advocate. We're expected to provide a compelling narrative that is not necessarily written in that sort of academic detached voice. And I think that can be better and worse, right? So here, just by way of a couple of examples, you know, on the plus side, it gives us more leeway than I think judges have. I think as advocates, we probably have a little wider lane in which to work before people will question what we are doing. But on the other hand, we're answering to judges who are going to judge our papers. And here's just an example from the Fort Worth Court of Appeals a few years ago in a takings case. A family had sued a municipality alleging taking by recurrent flooding. And these poor folks had been flooded like 18 times. And the city's attorney used a line from Creedence Clearwater Revival, "Who'll Stop the Rain?" And the court kind of let him have it. And it was interesting to me there because context is so important, right? The judges talked about, and Professor Dysart all talked about, you know, you wouldn't do this in a wrongful death case, for example. Well, this case is an illustration of that. If the homeowners had quoted Creedence Clearwater Revival, probably would not have been a problem. What agitated the court was that it was the city doing it. And so the court said, we assume that the quoting of the lyrics is not meant to make light of the homeowner's situation. So it really was, sort of a perceived insensitivity to, whether this is a constitutional taking or not. These poor people have been hammered by floods 18 times in 5 years. It's not funny. So I think that case both illustrates the danger to advocates that you may offend the court and the importance of context in these sorts of references. Same danger for judges. There was an opinion about 15 years ago in the Waco Court of Appeals that cited a song, a country music song by Jimmy Dean, and it contained the lyrics "Skip a Rope." And this was a criminal case, and the convict in that case happened to be African American and misunderstood the lyric, did not understand the lyric, and filed a motion for rehearing, basically claiming that the use of that lyric had been racist and seeking recusal and rehearing, et cetera, et cetera. And that prompted a fairly strong response from the justice who had written the opinion. But I think, again, it does show the danger that can be inherent in some of these sorts of things. I think the same concerns for advocates as have been enunciated for judges, but probably just heightened. Obviously, the type of case is critically important. We're not going to joke in capital cases and wrongful death cases and whatever the case may be. Who's citing the lyric, I think, can matter, as I indicated earlier, that it's truly relevant. And the most important thing is the same thing that's always true for us as advocates: know the court, right? Learn as much as you can, and what may be John, you and I both could think of district court judges in Dallas that we would use humor in front of without any hesitation. And we can think, and Jason as well, can think of some district court judges that we would definitely not think that would serve the interests of our clients. So I would say know the court. And if you don't know the court, err on the side of caution and not showing off, and play it straight. Because you'll never offend anyone doing that. The only other thing I'll pile on is this idea of cultural references that I think I talk about this a lot, as a couple of you have seen. I sometimes speak about legal writing now wearing a Buzz Lightyear costume, just to remind people that we used to write for the Wizard of Oz generation, and now we're writing for appellate judges who were raised on Buzz Lightyear. And it's just, they are not going to catch even your Bob Dylan reference may not land. And that's a little bit terrifying, but I know in one case I started to cite the Eagles, and then I thought, I'm going to cover all my bases. And I cited both the Eagles and Jay-Z because I thought I might hit two different age groups there. So those are just some of my thoughts. And
it sounds like you had 99 problems and references wasn't one of them.
That was the song, my friend.
Yeah. One of the greatest songs about Fourth Amendment doctrine that one can find. First of all, a quick shout out for those who have not seen Chad's presentation. When he is wearing a Buzz Lightyear costume, it is not to be missed. I can say the same thing about your outstanding Marbury versus Madison presentations, in which you wear colonial garb as well. You go all out, my friend, for the sake of the audience, and I appreciate that. Also, for those members of our audience who are interested, and I think if you're interested in the topic, you will be. Chad, I had the pleasure of reading an early version of an article you wrote on song lyrics referenced, and can you share with us where readers can find that, where it was published?
Sure. I've done a couple of them, and I did one for the Appellate Advocate on the use of lyrics in Texas judicial opinions. And by the way, one of the things I should say two things that are kind of interesting about that. One, I think, is that there are very few of these that are one-offs. It's a small group of judges who do it over and over and over again. And in fact, we have one federal judge in Texas who has used exactly the same lyric in like 4 different opinions. So I thought that was very interesting. And by and large, as you would expect, it's the same artists cited over and over and over again. So Bob Dylan, the Beatles, Bruce Springsteen are right at the top of that list. So there's one in the Appellate Advocate, and then I did one, Judge Klingensmith and I, from the judge from Florida, who's actually written a book about this topic. He and I did one in the Wisconsin Bar Journal that discussed the use of lyrics in Wisconsin opinions as well.
Great, thank you. And now Jason Steed, who I think should be familiar to our audience because of the wonderful presence you have on appellate Twitter. So I am a member and a fan, and my tweets are nowhere near as interesting or as relevant and enjoyable as yours. But you are also a preeminent appellate attorney and a former English professor. Let's get your thoughts on, first of all, the use of humor and pop culture references by judges, and second, by you from the standpoint of the advocate trying to persuade.
Well, I'll echo everyone else by saying thanks for having me. And I think this is a great topic and a great panel. I'm honored to be part of it. So I'll start with me as an advocate. I almost never do any of this. I was trying to think of a time where maybe I had, and I'm not sure there has been a brief that I've ever written where I've tried to do any of the things we're talking about. So I think it has a lot to do with, I don't want to waste words on that. I just, a lot of times to develop an allusion or a reference or an analogy, it takes words, and it's just not something that I think I've spent words on. I think in judicial writing, I think the goal for an advocate and a judge or a panel of judges, I think the goal should always be good writing. And good writing, I think, they're sort of the two pillars of good writing. One of them is, what's the purpose? Is the writing effective in accomplishing the purpose of that writing? And then who's the audience, which is a big part of whether or not the writing is going to be effective at accomplishing its purpose. You sort of have to know who the audience is. And I think you can have really good, really engaging, even enjoyable, good writing without any of the stuff we're talking about. Just really, punchy sentences, strong transitions, a good sense of tension and narrative arc. I mean, you can have all of those things without any pop culture references, without any literary references, without any use of humor. And I do think it's important to distinguish between all those things because I think they are distinguishable things. So I think, we should all be pursuing good writing, and these things aren't necessary to that, but they can contribute to good writing, I think, in the right place. And everybody's sort of mentioned the ways in which it can contribute to good writing. I do think if we're talking about pop culture references, I do think a real problem area for that is it assumes a certain, unless you're going to explain what the reference is, like the references to Game of Thrones, they're lost on me. I've never seen an episode of Game of Thrones. I have no idea. I sort of have vague ideas about what the show is about because I hear other people talk about it, but it means nothing to me to refer to Game of Thrones. And so unless the piece of writing that refers to it is going to explain a little bit about why this reference matters, I just have to assume somehow that's relevant and that somehow that explains something. So there's a certain assumption you make about your audience. And this is where the good writing, those two pillars, what's the purpose? And I think judicial opinions, if that's what we're talking about, are the purpose is to resolve the case, right? Resolve this dispute that's before the court. And probably the other sort of co-purpose is to say what the law is or provide some kind of guidance to the parties and to future parties what the law would be in this sort of situation. So, for that purpose, who's the audience and how do you accomplish that purpose effectively? And pop culture references can help that, I think, but you're sort of assuming certain things about the audience, like they know what you're talking about. And they are very dated. A lot of them are very dated where, if this opinion is supposed to provide guidance to litigants 5 or 10 or 20 years from now as precedent, are they going to really, is that reference really going to help explain what the law is for litigants 15 years from now? Maybe sometimes it will, sometimes it won't. One thing as an former English professor, one thing that drives me batty is when you'll see an advocate or a judicial opinion that makes a literary reference, but like that's not what that means, right? Like they quote Robert Frost's poem, The Road Not Taken, and they quote those famous lines, and that's not what he's saying in that poem. That's not applicable to what you just made that applicable to. Or a Bible verse will get quoted, but like that's not what the King James Version meant when it said those words. By and by, for example, in 1600, by and by meant immediately. It didn't mean in a while. But someone will quote the King James Version of the Bible and the use of by and by, meaning that'll happen eventually. And that's not what that meant in the Bible, right? So, I mean, that's a real risk when you're trying to pull literary allusions or pop culture references. You might be misusing something, and there might be someone in your audience who knows you just misused that. Or you're assuming they know something that they don't actually know anything about. And so I just think there's a lot of risks or problems with doing it. But I also agree with everybody when we talk about how there are situations where organically that really does make the writing better. It really does illustrate something. I think maybe one guideline is this a means or an end, right? Like we talked about a judge from the 70s who's slipping in all of these allusions to soap or something like that. To me, when I hear about that, I'm not familiar with that opinion, but that sounded like an end to me. Like there's a goal to slip in all this stuff. And that's a separate goal from the purpose of the judicial opinion, which is to resolve this dispute and provide guidance in the law. If the allusions or the references are a goal, my personal opinion is that's maybe not one of the right goals to have. But if it's a means, if it's an organic means to accomplishing the goal, then that can be useful, right? If it's a reference that is a means to illustrating a point, and it's a good one and an effective one, that can be part of good writing. Humor is a whole other thing. My PhD dissertation was on the use of humor in literature. And I think, at the risk of sounding like a curmudgeon or something, I just think humor should be generally avoided in legal writing, because the thing about humor is it tends to create in-groups and out-groups. That's kind of the function of it. We tell jokes with someone when we're trying to sort of become friends with them and bring them into our group, or we tell jokes because we're trying to push them out of our group and ridicule them and mock them. So when you're using humor, you're almost always creating in-groups and out-groups. And I think it's really risky that you're, especially in certain kinds of cases, as everyone's mentioned, the court is in a position where it's almost always going to be punching down at one of the parties. And so the risk of using humor and punching down at one of the parties is just huge. So I'm not a huge fan of humor. It's hard to do. That doesn't mean it's not possible. There was I think it was a copyright case with Taylor Swift lyrics where the judge used Taylor Swift lyrics in resolving the copyright dispute over Taylor Swift lyrics, I think.
Exactly.
And that was funny and playful. And like, I feel like that's fine, right? Nobody's being punched down at, there's no big in-group, out-group problem with that kind of humor. That sort of thing is, and it's relevant to the case. Like, I'm not completely opposed to it in all cases, but I just think it's really can be problematic.
Well, thank you. Great points, especially when writers, judicial or otherwise, make allusions and their references wrong. Now, Professor Dysart, you train lawyers and future lawyers on legal writing. Let's get you to weigh in on advocates, attorneys using humor in pop culture.
Thank you. Yeah, I normally think judges and attorneys should follow kind of the same general rules when writing, but this is one of the exceptions. I think attorneys need to be really careful about humor and pop culture references, both in briefs and at oral argument. I mean, I'm teaching oral argument this afternoon to my students, and I'm going to say something along the lines of, you are not Paul Clement, who knows when it may be appropriate to use humor at oral argument. I think if you know the judges and have practiced frequently in front of that judge or panel, you may know when it's appropriate, but in brief writing, you often don't know who your panel is and how your humor will be perceived. In working on the third edition of Winning on Appeal with one of Judge Ho's colleagues, Judge Southwick, the one thing that every judge agrees on is that they have to read too much and the briefs are too long. That is the single thing that every judge agrees on. And in my mind, humor and pop culture, if it adds and makes the brief longer, it's probably not effective. Now, when you look at some of the interesting, like the comic strip brief or the onion brief or some of those other, briefs, as amicus briefs to the US Supreme Court, those may be effective or interesting or make a point, because their point isn't really to persuade the justices. It's to sort of make a broader cultural point to all the people who read Supreme Court briefs, which is more people than read Court of Appeals briefs. But for the primary brief, to judges you're not familiar with, to the panel that may not be set, especially at the Federal Court of Appeals level, I think you just have to be really, really careful. And I would generally caution my students to not do it. I know Judge Owens, I'd be curious to see what the judges have to say on this.
Yeah, I'll jump in now. I mean, as an advocate, I was an advocate for almost 20 years before I got this job. I never did it. Never, 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 with one exception. If I was talking to a jury and I saw there may be a way to use a kind of funny example or a pop culture example, and with juries, that's usually a very good way to do it. You can analogize to this or that. He was like the Darth Vader of this gang, or whatever it is. You can use those examples in a way, I think, very effectively with the jury. It's a very good way to talk to people in that kind of, and when you're speaking to a jury, it's almost a social setting. But in briefs to the court, I never did it. And to the professor's point, if in the district court, if I'd appeared before a judge many, many, many times, and I could use an analogy like the Darth Vader of the gang or whatever it is, then I would feel comfortable. That's because I knew the judge. I appeared before this judge many times. To shoot blind on something like this, I think, is a very risky thing for an advocate. I mean, look, I'm a judge, right? I have a certain amount of leeway I get to have that I did not necessarily have as an advocate. And as to Jason's point, we do read a lot, and sometimes we'll get briefs that try to be funny sometimes. And what usually ends up happening is I'll take to my law clerk and say, you can believe this guy? Like, what is he doing? This is bizarre. That has happened. And so I do think as an advocate, you got to be really careful. Now, again, before a jury, that's a whole different story, because sometimes that's exactly the time you want to strike like that. But this is an appellate discussion we're having, our legal writing discussion. And yeah, I'd be very, very, so any law students reading this, you're not going to get, higher grades in your legal research and writing thing by making jokes in your briefs. It's not a good practice, in my experience.
Judge Ho, what do you think on the subject of advocates making use of these references?
I'm pretty sure I never did it myself as an advocate. I once surprised myself by doing it during oral argument before the Supreme Court of the United States, of all places. And thankfully it did not, it got a chuckle, and I moved on. I was just, I did it before I even realized it. Justice Kennedy seemed amused by it. But it's I would be very nervous if you're representing a client. Let's just say I've never, if I recall, never saw a situation where it met the threshold of, yes, this is worth doing. And at the end of the day, you're there to advance your client's cause. So if that's your role, then any attempt at humor or pop culture reference, if you're going to do it, it better advance the client's cause. Just sort of along the lines of what I said in terms of opinion writing, if it helps reinforce a substantive legal point you're trying to make.
Before I go on to our next question, I want to point out with my thanks to Chad Baruch that Justice Kagan is pretty well-rounded in her use of pop culture references. Besides Dr. Seuss, she also gave a shout out to the 80s song Jenny 8675309 by, and I'm dating myself here voluntarily, Tommy Two Tone. So the fact that I know that reference automatically tells you I'm just way too old. Let's move on. I'd like to pose some questions to all our panelists. In a recent 2021 Houston Law Review article, law professor Nina Varsava wrote that, and I quote, "Judicial opinion should conform to an even-keeled, impassive, and even formulaic institutional style," end quote. And according to Professor Varsava, judges who use humor and pop culture references in their opinions risk their impartiality and undermine the integrity of the judicial role and legitimacy of their opinions. That's a pretty heavy condemnation. I'd like to hear what the panel thinks and their reactions to it. Let's go ahead and begin with our judges. Judge Ho, your thoughts?
Yeah, I think that's an awfully categorical statement that, you know, as I think I opened with, it's, you know, I'm a resounding maybe, right? And frankly, just, you know, I think you could probably say this about a lot of legal writing principles generally. There are very, very few principles that are, you know what, you should always do X, you should never do X. I don't know. I think art writing is far more art than science. I don't agree with a categorical condemnation. I get where it comes from. Believe me, I'm not unsympathetic to the concern about this being, you know, serious business, deciding disputes and representing clients and all that. Nobody wants to diminish the process. I hesitate to say that every usage is per se such a diminution.
Judge Owens, your thoughts?
I agree with Judge Ho. I mean, we're not robots. I mean, look, if we want to go the way of analytics, we can have, you know, I'm sure there probably already are programs, right? I think there's actually been some research that certain parts of the government and administrative law is actually having analytics and algorithms draft opinions in certain areas, not for our courts, but for courts that have thousands and thousands and thousands of opinions. We could go down that road. We could. I don't think it's a wise thing. Some of the greatest opinions in the Supreme Court's history have been written with some flourish. There have been some expressions that really resonate and resonate for centuries. And we keep coming back to those lines. This is a constitution we are propounding. You know, maybe that's flourish. Maybe we should take that out. So I agree with Judge Ho that we should be careful not to overdo it. You know, don't put too much frosting on the cake, but, you know, sometimes you gotta be rhetorical a little bit. You've got to use a flourish. And if a pop culture way is the best way to do it, then in that case, it's appropriate. So I don't think the categorical approach. I'm not a fan of the categorical approach in criminal law either. I'm a big anti-categorical guy when it has to do with crimmigration. But here's another way I'm not in favor of this categorical approach, much like Judge Ho.
Can I go back to what I think Judge Owens said something that I want to reinforce is there are times when, just like in sort of really good legal writing, you can almost sum up an entire concept in a word or two now. If I were to say Justice Scalia and Wolf, I think many people would immediately know what metaphor I'm invoking. Justice Alito more recently using the term pirate ship. I think another Justice Scalia, or was it describing the lemon test as a ghoul, or it was something like that. I mean, those terms have become so evocative, it almost becomes shorthand into itself. And I would hate to impoverish our the richness of our conversation by just eliminating any such use of color.
Professor Dysart, your thoughts on the absolutism approach?
There was a lot that I disagreed with in this particular article. And I think some of it is conflating the different categories of pop culture humor. And then the author uses evocative or engaging writing. And I thought there's a huge difference between evocative writing and engaging writing. And to me, the premise seems to be no one reads opinions unless they have to. No one reads them for fun, which then I felt like a real nerd because I read them for fun sometimes. But so no one reads them for fun, so why make them interesting? And to me, that's kind of a chicken and egg problem, right? Shouldn't the public, who is deeply impacted by, you know, decisions from certainly the Supreme Court and other courts, shouldn't they care? And, you know, in June, when everyone on Facebook becomes a constitutional law scholar, I like to ask the question, like, did you read the opinion? Like, do you understand what you're commenting on? Because in fact, what you're saying is not at all in the opinion. You know, you've just completely misstated the opinion. So So I think opinions should be engaged. I think they should be shorter, and I've blogged on this on the Appellate Advocacy blog, but I absolutely do think they should be engaging and accessible. And it's interesting, I was thinking about Justice Gorsuch's opinion in McGirt. So I'm Muskogee Creek, and it was a huge, opinion for me personally, for my tribe, and I think for Native Americans in general. And I was listening to an ASU webinar, and that sentence from Justice Gorsuch, "On the far end of the Trail of Tears was a promise," was profoundly impactful to people from the Oklahoma tribes, and whose families were either forced to or sort of or voluntarily. My family voluntarily left our ancestral lands, and I think that it was a powerful, maybe evocative statement that really added to the decision in that opinion. So let's see if I can look at my notes. I think that, I guess one other thing I was going to say, she mentions that it touches on impartiality. And if I had to categorize a judicial opinion as objective or persuasive writing, so right, in the first year legal curriculum, we teach objective writing in the fall, persuasive writing in the spring, I would put it on the persuasive side. It's different than an appellate brief, but it's still convincing the parties that the judge reached the right outcome. And so it is ultimately a piece of persuasive writing. Now it needs to be, respectful of the arguments on both sides and discuss the arguments on both sides. But at the end, it's persuading those litigants and future courts and the other colleagues on the panel that this is the right outcome. And so I think that was something that was missed in the piece as well.
Chad Baruch, your thoughts on this very strong opinion by Professor Varsava?
Yeah, I don't have anything any different than anyone else has said. I don't disagree in principle. I have read briefs and opinions that I thought were inappropriate in this regard, but I don't think every single time someone uses one of these devices that augurs the end of Anglo-American law as we know it. I do think sometimes, they're two different things, right? The use of humor is one thing, the use of cultural references is something very different. And I think particularly the use of cultural references, the whole point there is that these are universalities that explain concepts or make them easier to understand. So I think that's fundamentally different. When Chief Justice Roberts, during his confirmation hearings, said the role of a federal judge is to call balls and strikes, my fourth grade daughter may not understand, at that time, fourth grade daughter may not have understood perfectly the role of a federal judge, but she sure understood what he meant by calling balls and strikes. That was just the perfect, and there was nothing cutesy about that or nothing about that denigrated the law. It just helped people understand the concept. And I think oftentimes, another one that lands for me, I know it's the most used rock lyric of all time, but Bob Dylan, "You don't need a weatherman to tell you which way the wind is blowing." That is just a perfect way to make someone understand the dividing line for when you need an expert witness and when you don't, right? It's just a really good reference. So I do think you have to be super duper careful. I think one thing that no one has said, but that I think is really important, is funny people who are not funny should not try to be funny. I happen to be charming, delightful, and quite humorous. So I'm quite comfortable, sparingly using humor, but I think you do have to be really, really careful because it may not land and then you just look silly. But sometimes I think about, I had a briefing waiver case in the Texas Supreme Court about 3 years ago, and the reply brief, I started with the Rush lyric, right? When you choose not to decide, you still have made a choice. That was the whole argument. I probably could have just spat that line out there and signed my name to the reply brief and been done. So I think sparingly used, know your spots. And as the judges have pointed out, most important of all, know your court. And if you don't know the court, don't take any risks. That's really, I think, the bottom line is know who you're talking to.
Jason Steed, your thoughts?
So I do agree with everybody else that Professor Varsava's maybe overstated a few things, stated a little more strongly than it needs to be or should be. But there's maybe, again, to be the curmudgeon or I don't know, devil's advocate or something. Actually, there's a lot about what she's saying that I agree with. I think she says that, the real purpose of judicial opinions is to resolve the dispute and say what the law is and provide guidance to future parties and that sort of thing. And I think it really comes back to, that concept of ends or means. I think the way I read her article, I think what she was getting at is that the witty or playful or folksy judicial opinion, if that's the end, if the end is to write this kind of an opinion to, attract media attention or audition for some other judicial appointment, or, if that's what's happening, that's not the right goal for judicial writing. And I agree with that. If that's part of what she's saying, I think that's right. I think you can have good, engaging, enjoyable, effective judicial or advocacy writing that is that's not that. So there's some things that she's saying that I agree with, but I do think she overstates, maybe overplays the hand a little bit, and is a little too categorical in what she's saying. Because I also still agree with everybody that good writing is going to include at times something more than what artificial intelligence would come up with.
We've gotten some, phenomenal questions. We may not be able to get to all of them within our time limits, but let me lead off with one that was posed, and that is from one of our attendees. Do you perceive gender limits on using pop humor or pop culture, except for the late Justice Ginsburg? All the references to humor or pop culture mentioned today have been used by male advocates or judges. Is the danger of using humor more inherent to female judges, advocates, or professors? Just quick note in slight defense, the judge who used the Taylor Swift lyrics was female. The judge who wrote the beer reference opinion was female. So if I didn't make it clear, some of what I was referencing earlier certainly comes from female jurists, but I think it's a legitimate question to pose to our panel. What is your response on this issue of any kind of gender lines in use of these references?
I think I once saw somewhere that, or I think maybe one of my clerks told me that Justice Jackson is the first to quote Hamilton. So I think it's a good question. I'm not sure I am competent to answer it, but it's certainly, I understand where the question comes from.
I think if you go,
Go ahead, Jason.
I was going to say, I think if we're pulling from examples, if you go back a decade or two, I mean, it's probably been a couple of decades, there are just a lot fewer women judges, right? So pulling examples from women who are writing judicial opinions, I mean, there just aren't very many. If you're like, a bunch of the examples we pulled were from the 70s. There aren't a lot of women judges back in the 70s. Certainly not as many as men.
And I was going to add, Justice Kagan is probably the leading person on the court, and she also referenced Spider-Man in one of her opinions. So,
right.
And the law clerk who gave me the idea for Game of Thrones was a woman. So I think as we see more women become judges and serve for a long time as judges, I don't think it's going to be an issue.
Yeah, I think as long as it's authentic and not forced, then, do women still face difficulties in the legal profession? Absolutely. I mean, absolutely. But, the key is if you're a funny person and you use humor, it has to be authentic. And I think that's the key. I use a lot of humor in teaching, sometimes like my current humor is go dog go and bluey, which my students don't always understand, but that's what I have a 2-year-old and a 4-year-old. That's sort of my life right now. But yeah, it needs to be authentic.
A related point, by the way, John, is that there's a law review article that tracks the citation of popular music lyrics across the country. They did a pretty comprehensive survey, and perhaps not surprisingly, the top 10 do not include a single female artist or a single artist of color. So it's not just the people doing the citing, but the citations themselves are overwhelmingly old white man citations. That's changing. Obviously, we have a former Supreme Court justice, one of Judge Ho's colleagues on the Fifth Circuit, that certainly has drawn some attention for citing some rap lyrics, and younger judges, I suspect that'll change, but it's certainly the truth now.
Let's move on to another question, and that is from one of our attendees. Do the panelists have an opinion about Brian Garner's approach? And has anyone used Ross Guberman's brief catch program on the topic of analytics?
I've used the brief catch program. Russ asked me to, I was one of the early people who kind of tested out how it worked and stuff like that when he was developing it. And I think it's a great program. And it really doesn't have anything to do with pop culture references and humor and all that sort of thing. It's just about helping to improve your writing. But it's a good tool. It's a useful tool. I'm not sure which of Brian Garner's approaches they're referring to when they talk about Brian Garner's approach. But
and I'm not either. I was hoping it may have jogged something in one of our panelists.
I'll say this. I'm not a fan of footnoting everything.
Yeah, I was actually about to say something similar. I'm a big fan of Brian Garner, just from the standpoint of, frankly, teaching lawyers how to write. You might dare say undoing how some law schools teach legal writing. Certainly not all, but I feel like, law schools almost teach lawyers how to write terribly by sounding like lawyers. And I think it's better to sound like human beings. But having said that, with the greatest possible respect for Brian Garner, who I think has been wonderful in so many ways, I've told him in person many times, I hate citational footnotes. I think it's a terrible practice.
In the interest of time, I want to get to as many of our questions as possible. There's one that I think is very apropos of our topic, and that is, aside from humor and pop culture references, what are some overlooked techniques in making opinions more accessible that you all enjoy? So whoever wants to weigh in, please feel free.
So I'll make a point of jump up, please.
I think, and this sort of goes to the point that Judge Ho just made, and I'd like to hope we're doing better in the academy, but opinions, I'm a first-gen law student. Opinions should be readable. I should be able to give my father, who didn't graduate from college, an opinion, and he's a very smart man, and he should be able to, in general, read it and understand, even if he doesn't know the nuances of ERISA. And so when I talk to my students, and when I talk on legal writing, I did a CLE actually last week to the Ohio State Bar. I talked about avoiding legalese. And I always like to share, there's a great short law review article by Eugene Volek and another professor, and it's free. So you don't have to buy Wittick's Plain English for Lawyers or the Red Book or, even Struck and White, which is a great example. You can just get this free article from Eugene Volek, and it hits on the key ways to avoid, legalese. An intelligent non-lawyer should be able to understand your opinion. And to the extent that analogies and metaphors and pop culture references help in that, I think that that's great. Or even someone put a question about, historical quotations, starting something off with a quote to sort of bring it into perspective, like, oh, this is what this case is really about, or this is why this case is important. Those are all, I think, very valuable writing tools that can be used. I will try to put a link in the chat if I can find it.
I think I heard the professor talk earlier very in passing about brevity of opinions, and I could not emphatically agree more. Opinions are by and large way too long. When I think of reading and the burden of doing all the reading that everybody here does, that's the number one thing I think of is if you're a judge and you're writing an opinion, remember you're essentially taxing the world as a tax, right? Like litigants and counsel have to read opinions to know what the law is to make good arguments. So if you can write a 100-page behemoth or 10-page or even a 5-page opinion, and either way, lawyers have to read it, and somebody has to pay for all that reading time. And so, to my view, every paragraph, every sentence you write, hopefully it adds value in some way. Otherwise, you're just making it harder on the world. So I'm big on on the professor's point about brevity, and relatedly, I'm trying to do this more and more. I'm not claiming to have achieved any real success on this, but more substantive introductions, so that the idea that you have to read the entire opinion to know whether it's worth reading the entire opinion just strikes me as wrong. I'm sure I've committed that mistake many times. I know I read a lot of opinions in private practice where I felt like, gosh, I really wish you just told me at the outset what you were gonna, what this opinion's all about. And so writing sort of not necessarily huge long intros, but substantive intros where you actually tell the reader where you're going, what the ultimate issues are, ultimate holding, as opposed to just a fact-intensive thing or something where it's literally like, this case is about X, and then you don't really explain where are you going with this.
Judge
I'm a
Owens, go ahead.
huge fan of putting the conclusion up front in a judicial opinion. I mean, just the client always wants to know, did we win? And the client doesn't want to read the 100-page opinion to find out whether they won or not. In the first paragraph, if you can say, this case is about this is what we decided, and now here's why. Huge fan of that.
Judge Owens, you were going to add something?
Yeah, I think this applies to practitioners that deal with specific technical areas of the law. For those of us on the Ninth Circuit, and I imagine it's the same on the Fifth Circuit, we have to deal with all kinds of stuff. And I am not an expert in this environmental area, or I'm not an expert in this marine science area, but people in those worlds, much like the computer guy always talks a certain way, and we often don't know what the computer guy is exactly talking about. Same is true with lawyers who specialize in certain fields. In their world every day, they're talking about this, that, or the other. That's not how I speak. And that's not how my law clerks speak. And so when we're reading briefs, if you're using acronym after acronym after acronym, and I have to keep going back to figure out, okay, so in this environmental, this is an EIR versus an EIS. It can be very frustrating. So I understand why you use acronyms, because we're telling you write your brief short. Right now we're saying, but don't use acronyms. But just remember that when we're reading the briefs, we are not an expert in your field. You're not writing for an expert. You're writing for someone like me, who's going to do my best to read everything, but I don't come in with 25 years of environmental experience. I don't. So remember, when you're writing to a Fifth Circuit or a Ninth Circuit, we are generalists. Maybe in the Federal Circuit, maybe you can get away doing that stuff because that's what they do all day. I would be horrible on that court. But we don't. So just remember that. Make it easy for us to read. Make it short and make it easy for us to read. There's nothing wrong with bullet points. There's nothing wrong with a simple diagram in the Ninth Circuit. There are lots of ways you can show us concepts that make it very quick for us to understand what you're talking about. Especially, like, for example, you'll have some kind of conspiracy, and sometimes having a little diagram showing how everything was connected, as long as the record supports that diagram, of course, is totally fine. So just remember who you're writing for. That is so important, right? We've mentioned a lot of Dr. Seuss stuff. You're not going to throw War and Peace in front of a 3-year-old, right? So if you're dealing with me, make it Dr. Seuss before you make it War and Peace.
Judge Ho, Judge Owens' reference to acronyms reminded me of a recent Fifth Circuit opinion that I think took the government attorneys to task for excessive use of acronyms, and it did so in a humorous way. I can't remember if this is one of your opinions or one of your colleagues, but you may know the one I'm talking about.
Yeah, I think I know what you're referring to. It's not one of mine, and I certainly agree. One of my sort of tests, certainly that I applied when I was in private practice trying to teach associates about writing, is if the reader has to constantly flip back to a previous page to figure out what's going on, that's a good sign that you need to keep editing. That is not a good sign that it's an easy to follow brief. And in an over acronymized, that's a new term I could create, brief, where like you literally, reasonably smart people reading your brief, hopefully, smart lawyers, smart judges, if they can't keep track of all your acronyms, they have to keep flipping back. And even worse, they don't even know where to flip back because the acronyms are, defined all over the brief. My goodness, I mean, people need to remember how little time judges have to deal with all these different cases. And if we're spending our time flipping back and forth rather than analyzing the legal arguments, that's probably not the best advocacy.
Well, in the interest of the reference to both time and the earlier reference to brevity, I want to leave our audience and panelists with a witticism from the Honorable Judge John Gillis of the Michigan Court of Appeals in a 1970 case, Denny versus Radar Industries, writing one of the shortest judicial opinions on record. It said, the appellant has attempted to distinguish the factual situation in this case from that in another case. He didn't, we couldn't, affirmed, costs to appellee. Certainly the model of brevity, and in doing so gave us all a chuckle. I want to thank first of all, our distinguished panelists for just a wonderful, thought-provoking, and lively, engaging discussion today. I want to thank all of our attendees for tuning in to this annual Scribes CLE webinar. And please, if you're not already a Scribes member, please go to scribes.org, become a member. You'll be glad that you did. Thank you all for joining us today. Thank you again to our distinguished panelists. And that's all for now.
Thank you.
Thanks, everyone.